Streaming live via the Internet. Welcome to ISP Radio, your weekly source for ISP-related news, events, and interviews with industry experts. If you deliver Internet via fiber optic, wireless, coax, or any other way, you're in the right place. Chat live with us weekly via ispradio.com every Wednesday at 11 a.m. Central Time. And now a brief word from our sponsors. Link Technologies, providing ISP consulting, support, and hardware for wireless ISPs. TowerCoverage.com, providing online RF coverage maps. Mimosa Networks, providing high-density, high-bandwidth radio products. Advanced LLC, providing retail and wholesale advanced communication services by matching providers with your bandwidth needs. And by Sitel, providing reliability in surge suppression. And now your host for ISP Radio, Steve Grabiel and Dennis Burgett.
Welcome to another edition of ISP Radio. I'm your host, Steve Grabiel, broadcasting from Moriarty, New Mexico, and I've got Dennis, our host and producer, running the show from St. Louis, Missouri, and out here, hot as hell. Kind of amazing. Monday, it was like 98 degrees at 10 o'clock, and it was painful in the morning. And then yesterday, it cooled off to about 94, 93 by 11, and I could notice a tremendous difference in just 4 degrees, but it was miserable hot. I think I drank about a gallon of water to keep myself hydrated, but geez, really, really hot out here. And we kind of bypassed our early monsoon out here. We've been getting some good rain while I was gone on vacation, and now it's just hot and dry like New Mexico is. What I've been doing the last week, just cleaning up some of those people that we tore down and rebuilt entirely new relay. Ran a couple of ubiquity AC point-to-points capacity from, say, 70 megs in the past to 200 megs now, and then we upgraded the entire access system up there with a Bitlomat, a Rocket M5 Titanium, and a Rocket M2, and it seemed to do pretty well. One of the things I noticed in the installation of the M2 was I guess the clients are so close to the access point that I was screaming at them, so I had to crank down the power on it to clear up that distortion, and that seemed to clear up the problem. But just in the past few days, I've been going out and upgrading some people from old Transios on that system. We upgraded to more modern M2 nanobeams or M5 nanobeams, and just noticed tremendous, significant performance enhancements. That's what's been going on my network. How's it going with you, Dennis?
Oh, I'll tell you what, it's been a great week. Very, very busy. That's always a really good thing. As you said, weather is always an issue. We have had, as I said last week, we have had something like 6.5 inches of rain in the past week. The rivers are flooded, roads are closed. It's a big mess here. On top of that, Saturday we had a little party to go to. It was actually pretty nice. Somehow it cleared up for one day on a Saturday of all days. But then on Sunday, you say you have it hot. We have like 92, 93. The difference is the humidity.
Yep.
It's breathe in, spit back out. Okay? I mean, it was just, you walk outside and it just hits you like a pallet of bricks, and you're like, just get to the car as quickly as you can. Because you just don't want to even be outside. The humidity was so bad. And, of course, we had a couple more days that were nice and hot and humid. Today's going to be another one. And then, of course, we also have rain coming back in the forecast again. So, as always. However, keep in mind that if you put in your gear correctly, out of all the gear we have up on all these towers, we've had all this monsoon rain, all this absolutely insane thunderstorms, etc. So far, not a dang piece of equipment lost, with the exception of an actual power outage causing an outage. Everything else works just fine, so definitely can be done, and you definitely have can keep up and running without problems. But this actually kind of brings us to today's guest speaker. Is that in some of these cases, these are people's homes that have a small repeater on them, and they pay for power. It's not like our power, our gear takes up, we give them free internet, and they get, internet service for free, and they give us power. I'm sure the power, if we gave them a $5 bill, they'd probably cover the power for the month. But, what do you do in those types of situations? It's always kind of interesting. Is it better for you to have your own circuit, and then you can run a generator out there? Or, how does all that work? And in some cases, we ran a generator, but usually those micro pops that are on homes, for us anyway, if that home is without power, chances all the customers are too. So it doesn't really matter if we got that right back up right away. But that's what's been going on. As far as industry news, we are in the campaign period for the WISP Board of Directors. There's 5 positions open. You can go to WISPA.org and find out all the information about those people who are running for those board positions. I believe there's 8 or 9 people running, and the elections will actually commence. Just remember, you will be able to vote on July 13th. So we have a little bit of time before the voting period begins. They are already quite active out on the mailing lists, answering questions. What would you do? All this kind of good stuff. So really good stuff.
Dennis, I've got the list here in front of me. Can I read them off?
Yeah, go for it.
We got Blair Davis of West Michigan Wireless ISP. We got Todd Harpest of MetaLink Technologies, Inc. We have Chuck Hogg with Shelby Broadband. We have Rob Johnstone with NCN Data LLC. We've got Mark Radabaugh, Amplex Electric, Inc., Peter Velasquez Sr. from XTX1. We got Daniel White with SAF North America, and Brian Young of Convergence Technologies, Inc., running for the 5 positions available.
There you go. So, we have a number of people running. They're all their information has been already put up there, so you guys can review it, etc. Upcoming events, though, we do have WISPapalooza, October 10th through the 17th. We have the Fiber Weekend. That agenda is coming along. We also have the main agenda and events. There's some events going on, trainings. The main show is from the 13th through the 15th. Again, if you are in the ISP-related industry, I would highly recommend that you go ahead and hit WISPapalooza.org or WISPA.org and go ahead and sign up. To be honest with you right now, you will save a considerable amount of money if you go ahead and get your conference pass now before before the July 12th deadline. You can actually register later on, but all of a sudden the pricing starts going up and going up and going up. You save over $100 right now. Actually, it's almost $150 right now if you go and register before July 12th. So make sure you go onto their website and do so. It should be a great, great show this year. Again, back in Las Vegas, but it will be at the Rio Hotel as well. Other than that, there is a couple other pieces of information, but I'll have to get you that a little later on. I think we can go on to our wonderful guest speaker today.
All right. Well, that, like Dennis said, he kind of segued a little bit about what we're going to be talking about. On today's show, I have the honor to have Larry Donahue on our show. Larry is an attorney and founder of Law for Small Business, and he's a friend of mine who has helped me develop my business from a legal standpoint, keeping me out of trouble. That's his specialty. And he is a technical lawyer. I like to brag about Larry in this fact that if Larry was out without work and was sitting around doing nothing, I could hire him and have him installing equipment in probably a week or less. He's that smart technically. So with that, I'd like to introduce Larry. Larry, you there?
Yeah, I'm here. Can you hear me okay?
Yeah, I hear you fine.
Great.
So Larry, tell us a little bit about Law for Small Business, how it got started, and tell us about a bit about your specialty and your technical acumen.
Well, thank you, Steve. I appreciate it. I'm an electrical engineer. I graduated 1 million years ago at New Mexico State as an electrical engineer, and before I decided to go out, I was working with IBM at the time, and doing internet stuff before people even really knew that the internet existed. I remember explaining to people why you would use email. And I kid you not, I had to explain it as it's like a fast fax. And people will be like, well, if we have fax, why do we need email? And it's funny today, it's like just you don't even have to have that conversation anymore. It's almost like the conversation of DVDs, why DVDs were better than VHS. And I used to explain it by saying, well, you don't have to rewind the tape. And that's what people seem to care about. But at any rate, so I've been around that long. But I went to law school right after engineering school, left IBM, and after law school, I specialized in intellectual property in law school, and I ended up going into IT consulting right out of law school because the IT folks, the internet was just starting to come into play, and I had a unique set of skill sets, and I was able to make quite a bit more money in the consulting world than in the legal world. But I was still an attorney doing sort of technical stuff, and there was a really interesting. There's a big overlap between legal and technology. So I have deep technology roots, but I am a pencil pusher at this point. And it's funny, as I was listening to both of you talk about your equipment, I mean, I know what the routers and access points are, from a theoretical standpoint, but I couldn't tell you who the latest provider is, or what the narrow beam means necessarily. But I could come up quickly. But what I do today, well, let me take one more step back. So when I graduated law school, I went into consulting, and I ended up working for a bunch of different high-tech startups as a corporate counsel and oftentimes a chief operating officer. And an example of one of those companies would be Fat Cow Web Hosting. And we sold that business, had a successful exit, maybe, 8 or 9 years ago now. And at the time, we were sort of neck and neck with GoDaddy. Fat Cow is based here in the Southwest. We were focused on hosting. GoDaddy was focused on domain names, and then we started moving into domain names. GoDaddy started moving into hosting, and then we tried to monetize our respective client bases as much as possible. And GoDaddy kept going, and they're doing very well. Fat Cow ended up selling and had a successful exit, but I wish we would have kept on going, but the owners wanted to sell at the time. But whatever. I had a lot of experience. We had maybe 35,000 clients in 92 different countries as a hosting provider. At any rate, I founded Law for Small Business 3 years ago because of my experience at Fat Cow and these other companies. And the experience was as follows. I would get a crazy demand letter from an attorney somewhere in like Alaska, totally unrelated to our jurisdiction. And as an attorney myself, I had trouble determining what should we do as an organization. And so I, would eventually go out and reach out to other attorneys to hire them for, specialized issues. And I found it really difficult to hire another lawyer. And there were some big issues. One of them is just finding somebody who cared about our small business and returned my phone call. And then the second thing is when I found that, they want a huge retainer fee, $3,000 to $5,000 right off the bat, just to look at a contract or deal with a crazy situation. And so I founded Law for Small Business a little over 3 years ago to try and go after the small businesses that most lawyers don't care about. And so I don't have retainer fees. I'll talk to people for a couple of minutes and give them some quick answers without them, having to spend a fortune. We have flat rate contract reviews. We have a lot of services just geared to provide quick, inexpensive, technical legal services to small businesses. And that's been my focus. And as a consequence, I have bakers and dog groomers as clients as much as I have ISPs and hosting companies. So I want to make sure you understand I'm not trying to pass myself off as the ISP expert of the world, or I'm not a telecommunications attorney either. But I have enough broad legal experience, especially in small business. And then I do have a lot of technology-based clients. I do have WISPs and ISPs and hosting companies. And interestingly enough, my job, what I'm seeing a lot of is, just getting them to clean. They're so technical and they're so good at what they do they sort of forget about the basics, like, oh my God, if I happen to fall off a tower and die, what happens to my business? They sometimes miss the basic stuff because they're busy being a propeller head and putting up cables or wireless access points everywhere. So I help them, get their businesses in order, help keep them out of trouble. I've been participating in a lot of acquisitions lately. And in particular, I have a couple of clients that are, they're basically buying up small WISPs in the rural communities. And so I'm familiar kind of what the value proposition is there. And interestingly enough, it relates to infrastructure. And it's not, how many routers do they have up, but it's, do they have long-term leases in place? Contracts that they can rely on and turn those. And there's actually a value that, some of my clients that are buying these businesses attach to these contracts. And so, I do help, WISPs and ISPs trying to maximize the value of those contracts or the term of those contracts. And then there's everything in between, the DMCA issues and terms of service, privacy, and so on. So I think I blathered on a little too long. I apologize.
Well, no, you brought up some good points. And in all honesty, folks, I've been working with Larry for quite a few years, I think even before Law for Small Business, and he helped me develop my terms of services on my website and my acceptable use policy. And what I really love about it, it's completely readable. And at the beginning of it, he kind of puts it in a humorous bent, but at the end he does go through the lawyerese stuff. It's actually a really good document. You might want to look at it if you would like. It's at higherspeed.net. But so you brought up some good points. We've had Jab Electric, who's a huge consolidator of ISPs, and Jeff was on the show, and he told us about, when he goes for acquisition, the things that he's looking for. And he said primarily is, I want to see contracts for site leases. And Larry helped me develop my site leases, and at the behest of Jeff, if I want to sell this thing, I'm actively going out there and keeping the handshake agreement, but backing it up with paper. So, Larry, a lot of us ISPs out there, we have equipment on people's houses, like Dennis said, and just micro pops on people's houses that provide internet to the community, and it's a handshake agreement. What, from your standpoint, do you have any stories about how that might have bit someone in the butt and the importance of solidifying those handshakes with paper?
Oh, my Lord. I got too many. What's funny is, I sort of use two anecdotes when I talk to my ISP clients in particular. And it's one of them is, we lawyers we're either the hero or the goat, right? It's people look at the money they spend on a lawyer as a total waste of investment if there's no problems, right? It's like, well, why did I need that damn lawyer? Nobody sued me. I haven't had any problems, and I get it. And then the flip side is if there is a problem, the contract or document that exists will be scrutinized to such detail that a word difference between will or shall or a comma or lack of a comma could have significant impact. And so it's really this weird fight where people don't want to spend a lot of money for legal services, and I get it, but in the same time, they don't value the service until they actually need it, almost like insurance.
Yep.
And so the other piece is that, like for instance, a lease, a tower lease. I mean, right, ISPs, if you're doing your business well, what I see is those successful ISPs are developing repeatable processes, right? And an example would be, if you have 100 different, access points, you don't want them by 100 different manufacturers. And then managing that would be crazy. And the same thing goes with like your contracts and stuff. If you can come up with a repeatable process, that means that I have to give you a lease template that is flexible enough for your business, yet you can use over and over again, so you don't have to keep hiring me every time, but you also understand what the major components are. And, that includes things like indemnity and, is a big one. And then at the end of the day, a contract is and this brings me to my second anecdote, is it's really designed to protect both of you. And a handshake agreement is fine, but backing it up by a piece of paper protects both of you in case, heaven forbid, there's a change of control with the ISP, or heaven forbid, the person you're shaking hands with dies or becomes incapacitated or wants to sell their property. So, it's an important document. And to standardize that in a way so that you can use that throughout your business without having to come up with creative deals every time really helps with the value of your business if you're trying to sell it, and it reduces your costs as well because you have a standard process for all of this stuff. So I don't know if I answered your question right, Steve.
Any horror stories? I can tell you my own horror story, and it goes to the contract you wrote for me. So I got a deal, and we put it together, and it's rock solid. Even the guy who didn't want me on his side anymore agreed. It protected both him and I. He did not want me on his property, so he chose his option to kick me off, and that's fine. So we went and picked up the equipment this last weekend and put it back up on another site, of which I'll have another contract. But that, like you said, it protects both him and me as the ISP. And it clearly defines, what you will do, what I was going to do for him, and what he was giving up in exchange for allowing us to do what we did. But that being said, your contract is pretty darn rock solid, and he just exercised his option to get me off, but he did it within the terms of the contract, meaning he gave me the 30 days to get off the property.
Yeah, and that's the thing, right, is contracts are not written because the relationship's going well. The contract is written in case there's a breakdown for some reason. And so that's why, it's funny, I think we lawyers, people don't like us lawyers very much, and I get it. Nobody wants to get a demand letter or cease and desist letter from my office, number one. And then number two, we have to think through, right, we got to rub the crystal ball and say, okay, well, there's this ISP. What can go wrong in 2 or 3 years, and how do we want to account for it on this piece of paper? And, that brings me to the horror stories. But interestingly enough, if a business has gone through the process of coming up with a pretty good document like you have, there aren't so many horror stories. It's the horror stories are when those contracts don't exist. And it's really interesting. Probably half my revenue comes from what I'll just loosely call dispute resolution. The proverbial crap has hit the fan, and somebody's got to hire a lawyer and spend money. And so that's where all the fun, interesting stories are. When you have a contract in place, it's not a horror story. Unless somebody chooses to ignore the contract, to cut their nose off to spite their face kind of thing. Then, we get to some interesting issues. But the contract is going to have a mechanism. If somebody wants to leave this contract, what does that look like? Follow the process. That's the point, right? To get rid of the uncertainties in an emergency situation because somebody just went unplugged a router. Instead, they called you saying they wanted to terminate the contract. So the horror stories, and funny, I got a few of those with you, Steve, and I won't disclose those, but it's relating to where people are removing equipment from the ISPs, or they're taking something upon themselves as it relates to a network or a host. And one of the nightmares that I had is an ISP who is having a client doing, the traditional peer-to-peer, not network. What am I trying to say? They had the BitTorrent. God, why am I having trouble with that? So they had a BitTorrent farm in their house, and then the ISP threatened to pull the plug unless they stopped, and then they went and sued the ISP. And the problem here is the BitTorrent client was making a lot of money on this stuff and had a lot more money than the ISP to pay for legal services. And so that was an interesting story because I had to, basically play chicken with a very expensive, high-profile law firm. And the trick is to figure out how to add some penalties somehow so that if I can argue or prove that, hey, you're going to lose your case. Yes, you have a lot of money. Yes, you guys are great lawyers. And yes, we may have to hire an attorney in your city to help represent us, but you'll eventually lose. And when you lose, here's what it looks like. It's not simply we're fighting to keep your client on the network or to be able to remove your client, but we're now fighting for all these other damages that we've incurred. And by the way, the law that applies in this state versus your state allows treble damages. And then it also allows for legal fees. And so that's the situation that I need to be able to argue confidently to try and play that game of chicken so that my client's not spending $70,000 in a legal bill to kick some moron off of their network. Yeah. So that would be one example, and I'm sorry I can't get into more specifics.
No, I mean, just what you threw out there, I mean, BitTorrent and torrents of any nature are the bane of any ISP's existence for sure. I mean, it's a tool that's thrown out there, but you don't use you can use a hammer to hammer in a nail, but you also could use it to bash in someone's head. So, but it's by and large used nefariously for illegal stuff, as we all know. And within my contract, of course, Larry wrote up the contract saying that's strictly prohibited. If you don't like that, then you don't have to be on our network.
So I'm just going to toss my little comment and questions in here, because I know these are questions that other ISPs are going to be asking. So since we're on the topic of BitTorrent, so one of the big problems we have is, especially with the new Title II stuff and net neutrality stuff, which is still, I know that's outside probably of our scope of here, but as long as the content is lawful, it should be allowed. And I hate to sit there and make sure I inform everybody, I do a lot of BitTorrents that are perfectly lawful. When we look at some very popular games, so World of Warcraft, for instance, is using a BitTorrent distributed client inside their game to be able to do these 8 gig patches and 8 gig and 6 gig updates to the game. Is it actually BitTorrent traffic? And the answer is yes, it is BitTorrent traffic, but it's perfectly legitimate traffic. Now, while we do know that probably most of the traffic is not legitimate, obviously it's very hard to stop this. And this really kind of comes into the second question, or the second section, which is probably even is a better argument or a better way to talk, or a better topic to talk about, is the DMCA notices. I have been on both sides of DMCA notices. I have submitted DMCA notices to hosting companies to get my copyrighted material taken off their servers or taken offline. And I have been given DMCA notices in multiple forms. So, from a legal point of view, what should an ISP in general do? And whenever I say that is, I have an ISP, I have blocks of IPs, and I'm getting emails daily of DMCA notices saying these are copyrighted materials, everything from games to movies to who knows what else. And in those particular instances, how am I, as an ISP, to either become to get into a safe harbor status, or to ensure the validity of these requests? Because I'm getting an email in many cases. Is that the only way? Is there another way? Is there something else I can do to ensure that the request is legitimate and I'm not sitting there spinning my wheels for requests or DMCA notices that are completely automated in some fashion that most likely does not come from a actual copyright holder?
Dennis, just for my edification, give an example. You mentioned before the show about receiving bogus emails and what they're asking. I mean,
we get tons of DMCA notices, and the email DMCA notices are they factual? I don't know. That's not my job to figure out if they're factual. Okay, but it's just an email, and I have no way as an ISP to verify the authenticity of that DMCA request. I have no way, at least inexpensively anyway, I have no way of saying this email came from a copyright holder or someone who is working on behalf of the copyright holder. And there have been many, many documented instances of copyright trolls out there sending DMCA letters in the efforts to simply extort. Hey, we'll settle out of court for $100 or $500 or something dumb. If they send out 1 million requests and they get 1% of that, guess what? They're making good money. So that's the point, is how, as an ISP, should we go through that process? What do we do? Do we just take that email and forward it to the customer if we can identify it? What if we can't identify the customer? Maybe they're natted. What happens then? Are we just up the creek without a paddle, and now somewhere along the lines, if it's a valid request, we're going to get sued? Or is that not the case? Or is there another process to go through? For instance, whenever I submitted to a web hosting company for a copyrighted material I had that was being hosted by another company, they actually have a form. This form is a PDF. You download it. You have to actually take it to a notary, get it notarized, and then mail it to them. And I mailed it to them. It did not cost me anything. And within 3 days of them receiving that, they took down those servers.
Okay, that's kind of what I was asking.
Right, but how can us as an ISP, we don't want to fire our customers because someone else says so, especially when we don't have any type of method of proving it. Personally, to me, getting off onto the political topic, is that the whole DMCA system is completely broke, flawed, and it assumes you're guilty before they can prove anything. Besides that fact, I'm not worried about that. I'm more worried about my customers who say, hey, I'm getting this notice. What do I do with it? What should a ISP do? We have terms and services. Why do you not have a DMCA policy? Or is your DMCA policy in your terms of services? Don't know. How about that one?
That's really interesting. I got a lot of different things to say here. The first thing on BitTorrent, let me briefly go to that. And I agree with you. There's a lot of legitimate reasons for BitTorrent. The problem that what I'm seeing is that there are illegitimate files that will appear on an otherwise legitimate BitTorrent server. And what happens is that you start getting these DMCA notices frequently against the same customer, which ends up becoming sort of a hassle for the ISP. And that's where they need to decide whether they want to get rid of somebody like that. And my sort of goal as a lawyer, and what we do at our firm, is to keep people out of court. It's expensive. It's emotionally draining. And so, I like to try and answer these questions from that perspective, because it's sometimes a different answer, right? One answer would be, well, if you were to go into court, right, you can never predict anything when you go to court, by the way. You never know what kind of judge you're going to get or what some of the factual issues are. But that's one answer. In general, here's what the law says, and here's how we think the court should rule. But that's not necessarily the answer to stay out of court. And DMCA is a perfect example of this. And you mentioned it briefly in that DMCA, as it relates to what we care about, is the safe harbor provision. And what does that mean exactly? Well, the safe harbor provision allows an ISP to use it as a defense if it becomes part of a copyright infringement action, in particular contributory copyright infringement. And why it's an issue is because there's two laws that I can think of off the top of my mind that have strict liability attached. Strict liability means you didn't know. Three, now that I'm thinking about it. So I didn't know the girl that I slept with was 15, right? You've all heard of that one before. That's a strict liability offense. It doesn't matter if you knew or not. It doesn't matter if the other party lied. The other two strict liability offenses, the second one is child pornography. That's a big issue for hosting companies in particular, because they're liable. If it's on your server, you're liable. There's no excuses. Knowledge is not, or intent is not a component of the crime. And then finally, copyright infringement. And the problem with that is there's statutory damages attached. So you have a lot of copyright owners out there, including the the movie industry and the recording industry and the publishing industry who will use the Copyright Act like a huge club and sue everybody they can. So the DMCA is actually our friend because it gives us the safe harbor provision that we can use as a defense in case we get dragged into a lawsuit relating to some sort of contributory copyright infringement claim. So now why did I tell you all of that? Because I bet you half your listeners aren't even properly registered with the Copyright Office. And if they're not registered with the Copyright Office, it doesn't matter whether they're following the DMC provisions or not. You're not going to be able to use that as a safe harbor provision. So literally half the ISPs I talk to have never bothered to send in that little, it's called an interim designation of agent to receive notification of claimed infringement. It's a long worded title, but you go to copyright.gov/online ISP, and it's in the right box under resources. Online, is it online ISP? Yeah, it's online SP, excuse me. There's no I there. So if you haven't filed that document, do so. Otherwise, it's pointless even discussing the DMCA for you. You have to have filed. So let's presume you filed. So now the DMCA allows you to claim safe harbor if you follow its provisions. And it doesn't require you to validate the authenticity of a claim. And I would argue that the experience you had where they made you go and notarize something, they're not following the DMCA. You do not need to verify the authenticity. You just need to make sure it has the elements. That's all. Whether it's in an email or a fax or whatever. If it has those, 7 or 8 elements, and we can discuss that in a minute, that's all you need. And your job is to simply forward that on to the owner if you know it, because if you don't know who the owner is, that's one thing, but you have to take down the content. Now, what I recommend is you make it really easy for your customer to file a counter notification, because that's all you want. If you think it's bogus, you got to apologize to your customer and say, look, this is out of my hands. This is a legal issue, but here's what you do. You file this counter notification, and oh, by the way, here's a form that you need. Just fill that out and send it right back in. And then, the law says within not less than 10 days and no more than 14 days, you'll put the content back up. So you'd send the counter notification back to the alleged copyright holder that submitted the complaint in the first place, and then put the content back up in 10 days, and then your job is done. You're out of it. They can threaten lawsuits all they want, and you'll be able to invoke that defense. So I know it's frustrating, and I know you get a lot of those emails, and my advice is to put some sort of process in place to figure out whether it has the required elements, and if it doesn't, you kick it back. It doesn't have the components. And if it does, then you send it on to your customer if you know who they are and give them the counter notification, or show them or tell them how to do the counter notification.
Very, very powerful stuff we're learning here about DMCA. I'm a dummy. What's the acronym stand for? Oh,
it's the Digital Millennium Copyright Act. It's Title 17, Section 512 of the code. And in particular, it specifies how an ISP or an internet service provider can defend themselves against contributory copyright infringement claims by copyright holders.
So I just want to make sure I point this out, or I want to make sure I'm clear on this. So we get one of those. Regardless of any verification, we are required to turn the customer off?
So let's be clear about what we're talking about with verification. You don't need to verify the authenticity of the complaining party. What you have to verify is that they have the 7 components necessary, the 6 components. I can read them to you.
So I can take those 7 components, email your web host that's hosting your website, and say your website's infringing on my copyright, and they would take down your website.
They have to. If they want to take advantage of the safe harbor provisions
I understand that. Again, we can argue if the law is right or wrong. I understand you're telling me what we have to do. I just cannot believe that with no court order, nothing that says that they again, I can make a completely fictitious request and it breaks, the system breaks. You know, what is the harm and damage that occurs from an email from some person you don't know that comes in and takes down your website or takes down a site that generates, $100,000 a day? You know, can I put a DMCA notice to Amazon, say take this off your site?
Oh, I know.
I mean, to me, it just seems insane. That's all.
Well, and I don't disagree with you, but there are some remedies here, and let's be clear about those. One is you can choose to ignore the request if you feel it's illegitimate. You run the risk, however, that if it's not illegitimate, that you can be part of a contributory copyright infringement claim. So that's the issue, is do you think there's a risk of you being sued for that? So if you want to weigh that risk and say, well, this client's making $100,000 a day, I don't want to take them down. However, if you do, two things. One is your client has a cause of action against the complaining party because they are making that request under penalty of perjury. That goes a long way, and they can go and get damages and possibly more from that complaining party. Now, the second thing is, and you have to weigh this, but if I have a client, and I'm an ISP, and they're making $100,000 a day, and they are begging me not to take down their website, well, then they should be willing to sign an indemnity agreement with me. And if I'm going to purposely not take advantage of the safe harbor provision of the DMCA and therefore not do a takedown notice, I want my client to at least agree to indemnify me if we become party to a copyright infringement lawsuit.
Can you put that in your terms and service agreement?
But yes, you can. Yes, you can. Although something like that, I might want, I would recommend something maybe a little more custom and specific, because the customer, there's a communication going on with you and the customer, right? The customer has told you this is a $100,000 a day business, don't take me down. And so the customer needs to see you're going out on the line for them, and that I want them to acknowledge that on a piece of paper today that they are going to indemnify you if a claim comes. Because here's why. Your terms of service, you think about it, how long does your terms of service last? And what I mean by that is if I'm a client today and I have my service with you for a month, how long can you enforce your terms of service against me a year from now? Depending on your terms of service, you probably can't, because I'm no longer a customer of yours. But you statute of limitations on a copyright infringement claim, I forget exactly what it is. I want to say it's 5 years, but it may be 3 years. I can get sued for that action 2 or 3 years from now. So what you really want is an indemnity agreement that will last at least a statutory statute of limitations for this particular alleged infringement claim.
Right.
And I'd want my client to tell me if they're not infringing. And I'd want that on the piece of paper as well. So there's mechanisms here that an ISP can take advantage of, but not be in the role of a judge. You want to avoid that because that's where liability can come from. And it can happen years from the incident, when the customer's not even a client anymore, when you don't even have all the facts, you sort of deleted the emails. I mean, that's when I see real disaster happen for some of my clients.
So let's go back to this. So first off, if you're an ISP, you need to register with the Copyright Office this interim designation of agent to receive notification of claimed infringement. Would that be correct?
Yes.
Okay.
It's a one-page PDF.
Gotcha. And it's $105 to file. Looks
Yes.
like. Okay. So you need to do that. Then you need to have, based on net neutrality, I would not think you can even put in your terms and service anymore that you can't do BitTorrent. You can just say unlawful traffic. But that's probably, like I said, that's a Title II thing, not really another thing. Then,
well, don't forget that even with the net neutrality, you can still protect your network. And so you need to think of having the right provisions in place. You need to be able to take customers down if they're going to create a problem for the rest of your customers. You still have that right.
All right. So you have that. And then any of these email DMCA notices, there is some type of 7 devices or 7 things that you have to have. And as long as you have all those 7, your job is not to do anything. If you can identify the customer, then you will basically forward that on and keep record that you forwarded that on. Would that be correct?
Yes, that would be correct.
Okay.
After you've verified it has the required elements.
As long as it has those required elements. Okay. Now, with that said, you don't have to turn them off, correct?
Well, no. You do have to turn them off, but they have to let me see if I can remember that. They have
to be advised for sure, right?
I'm sorry?
They have to be advised?
Who has to be advised? What do you mean?
The offender.
No. The offender, you don't have to really do anything other than take down, you want to forward that on to your customer and give them the ability to do the counter notification, and then you have to take it down within the statutory.
Now we can't take it down. We're just doing the. So again, we're going from an ISP perspective, not a hosting company perspective. Let's do this one. This is just I'm selling them a pipe, and maybe they have a public IP, maybe they don't. Okay, but let's say they have a static public IP because we give all of our customers static IPs. We know which customer that DMCA notice is for because we have that IP. We forward that on and we say, here it is. We are giving it to you. You need to do your due diligence. But at that point in time, we can't take. The only thing we can do to take them down is to turn off the internet. In which case, then they're not going to get their email because they don't have no internet.
That's a good point. Everybody, when I think of ISPs, they're always doing some level of hosting as well. But you're right. If it's just strictly a ISP perspective, just pass it down. That's all you need to do.
Okay, so you pass it down, and as far as safe harbor, as long as you've filed, at that point you're done.
Yep.
Okay. Now, I have been told by several other people that what they recommend is putting a DMCA process that is not just a, quote, email, that is free of charge, that says if you think one of our clients is infringing on your copyright, here is this form that you're going to sign, and it may be a PDF, and you can email the form, or you can digitally upload the form, whatever the case is. And once that's done, we will process it because that form requires all that information, etc. I guess, and then that will eliminate the thought process behind that. Is that eliminates the trollers, the people who have some type of automated process to just spew out emails that have either may or may not have validity. It doesn't matter. The thought is that this is our policy. You follow our policy. Is that true or not?
It's mostly true. So
remember, you're talking to a lawyer.
Yeah, no. Well, I mean, but that's important because I know of one ISP that they would probably have a full-time person sitting there forwarding these DMCA requests to one of 30,000 subs that they have. Okay, they get a lot of them. But the way I understand they operate is they have a DMCA form right on their webpage, and that form simply says if you think if one of our customers is infringing on your copyright, you fill this form out. You hit submit. The submit, it's a digital form. There's no cost to it, but the difference is they're just not getting an email that can be easily generated, and then they go take down servers or take down customers as needed.
Yeah, for YouTube does that, for example. That it comes to a big provider that is coming to mind, but they have content on a server versus being an ISP.
But it'd be the same difference. Is it not the same difference? Or?
Well, the problem is the statute requires notification. So, as a lawyer, I just have to notify them. I don't have to follow their stupid process. They may try to get me to do the process, but as a lawyer, I don't give two hoots about it.
But if you email, one, there's no guarantee of confirmation of delivery, so how can you say I was notified?
No, well, remember, what I have to do is send a notice to the designated agent. That's all I need to do. So what I would do as a lawyer is if I don't have their email address, I'd send them a certified letter. And if they don't want to accept my certified letter, I'm fine with that too. Now, I got proof that I attempted to give them notice, and they refused to receive the notice. And if they do sign it, then they have the notice as well. So what you see is people will file the designated agent and not put an email address for that. And so what you can do within your terms of service is you can have the process and list your designated agent on the website with a mailing address and do it that way. You could put a form on there, but don't put an email address. It would be one way. And the law says they have to notify the designated agent at the end of the day. So if they're going to send a random email somewhere and it's not to the designated agent, that's their problem, not yours.
Okay. I actually just for other information, I actually just tossed a link between us that you can take a look at, and it specifically says what one company, and this is a very big company that does this and such. I'm just trying to make sure for our listeners, what do they need to do? You know what I'm saying? So let's get off the topic of DMCA. First off, for everybody that has been listening, you must fill out this copyright.gov form, interim designation of agent to receive notification of claimed infringement, which to my knowledge, basically what this says is that this is telling the copyright.gov who the registered agent is. Or the designated agent, basically. And you do have to pay for that. It's $105 for a filing fee. Once you do that, at that point in time, any DMCA notices that you get that have all 5 or 6 of the proper things, you must forward that on to your customers. What if you do not know? Okay. Hold on here. Looks like we got a call. What if you... I'm going to put these guys on hold real quick. What if you do not have... Let's say you're natting. What if you don't have a name? What if you don't have a public IP to tie back to your customer? You're natting 200 customers.
Such as myself.
Yeah, and if you're natting, what can you do? Are you just SOL?
Well, at the end of the day, what is a DMCA request? It's a takedown notice for taking down infringing content. And you're not in control of that content. You don't have the ability to take that content down. So there's really nothing you can do about it at that point. And I don't think you need to worry about it.
Well, that leads to the question that we have in the chat. Let me read it to you. You seem to be confusing taking the content down with taking the customer down. And Dennis mentioned this from an ISP standpoint. As I understand it, the customer has the obligation to take down the offending content. The ISP does not have an obligation to cut off the connection. And is that correct? I think that's right. I mean, just because we get that notice, I don't have an obligation to shut him off. He just has to take that garbage off the net. Is that right?
Yes. In general. However, I can think of factual situations where that might not necessarily be the case. For instance, if they're providing notice that the internet connection is only used for, infringing content, although something like that, I would probably push it to the realm of a court order.
Yeah, that would be something more. Real quick here, I know we had someone try to give us a call. I apologize, we missed that call. If you want to call us right back real quick, we'll go ahead and take that call and see if we can get your questions answered before we move on to our next topic here. Let's see if we can get that call real quick here. I apparently missed it and did not toss it in hold. I was supposed to grab it and toss it in...
you hung up?
Well, I actually just didn't answer it. I was trying to answer it and put him on hold real quick, but I didn't.
So, Larry, from my standpoint, my ISP, should I have some language on there in addition to the terms and service and acceptable use policy? Should I have something in regard to DMCA?
I don't think it hurts. You're not doing any hosting whatsoever, though. So, at the end of the day, it's really not something you're going to be able to take advantage of. But if you do have it as part of your process and you've listed it, and if for heaven there's some sort of BitTorrent cloud on your network that you're not aware of, it'd be at least one more arrow in the quiver of a defense attorney if you were fighting off some sort of copyright infringement claim.
And I think a lot of this, keep in mind, is you are providing a pipe. And if you don't have an obligation to cut off the circuit, then there's really nothing you can do other than pass the buck in that. And in a lot of cases, the only reason why they are sending us these emails is because the IPs are registered to us. Okay?
Yeah.
And they're using the email on the IP registration, on the ARIN registration or something like that to be able to find out who to send it to. Because a lot of these guys are not going to be a registered agent or have anything like that online. So...
And so I'll just tell you right there, the statute requires them to notify the designated agent. So if they're not notifying the designated agent, it's something you can...
What if you don't have a designated agent?
Well, agreed. You need to get the designated agent in place.
Okay.
But once you do, they have to notify the designated agent. And, you don't follow it at your own risk, but an email to info@ or whatever you have listed as part of your IP range is probably, hopefully, not going to be your designated agent. And therefore, you can choose to ignore those things.
Gotcha. So there we go. We have plenty of information. I think it's maybe the person who tossed on our chat. I hope we answered your question since I don't see the call coming back in. What I like to do is shift topics here. I know we've been talking plenty of legalese here. Let's talk about this. We talked about what every ISP should have. So what should they have? Should they have a terms and service? Should they have the what should they have? Should they have terms of service? Should they have a DMCA notice? Should they have privacy policy? What are the gotchas, the things that you've seen where an ISP should have had something such as one of those types of documents and they didn't? What are the gotchas in those particular aspects?
Well,
obviously,
I think that's
probably 500 of them, but...
Oh, my Lord. But I think, what's interesting is, stepping back for a minute, a lot of my small business customers, ISP, hosting companies, IT, services companies, they sort of started out small and started growing. And somewhere in the process, they sort of forgot to put the initial foundations in place. And so what I mean is that, for instance, they're not operating underneath a corporate umbrella. So one is to form a corporation, an LLC or an S or C corporation if they haven't done that already, and make sure that the right formation documents are in place. The next piece I find is they have a brand name that everybody knows them by, but it's not necessarily their company name. And at some point down the road, 3 months, 6 months, 2 years later, they sort of forget what the name of their company was, and they're signing contracts and leases and doing everything under their brand name, their DBA. But they haven't filed the DBA properly, and the DBA isn't an actual entity. And when you sign on the DBA as opposed to the company name, you're exposing yourself to liability, and it creates problems for the contracts. So my first piece of advice is make sure you have all the formation pieces correct, and that your existing contracts have the right party on it. Not your brand name, but your actual legal name. And then the next piece is that there's sort of, I think, 3 different types of contracts. One is the contracts with your customers. And, depending on the service, like, for instance, are you selling people door to door? Well, you can't really use click wrap there. So you need some sort of, services agreement that would work for your business process. But there's ISPs, you go online and you get, established just by, filling out a form online. And that has a click wrap agreement, which has some different issues. Both documents want to refer to an acceptable use policy that you should have online, a privacy policy that you'd have online as well. You got to word them carefully so that you can change them without having to have people sign new contracts. And here's a quick footnote. I have a lot of businesses where they will put a lot of details in their contract, so much so like pricing, for instance. I don't recommend you put pricing in your contract, which sounds kind of ridiculous, right? Well, why would you not put pricing in a contract? Well, because you might want to change your prices over time, or maybe have different tiered pricing over time. And if you put it in your contract, it means you got to get people to sign a new contract in order to enforce new pricing. And that would just be one example. The other two areas for contracts would be your vendors, and making sure you have decent agreements in place for your networking providers. If you have hosting or other third-party services, you have those, right? Those are pretty standard, although I recommend you at least negotiating them relating to termination and penalty clauses. Those are usually negotiable. And then finally, the third batch, and we touched on them earlier, would be improving or increasing the value of your infrastructure. And so those are the lease agreements and the tower agreements and other documents you'd have in place to enforce and maintain your infrastructure. And I think those three groupings are all really important. And the value of your business will be measured on those. If you don't have contracts in place at all, there's very little value to that. And if you can manage or maintain a long-term contract with the profit centers or the infrastructure components of your business, that's going to add to the value of your business. And likewise, if you can reduce the terms on the cost components of your business, the hosting vendors and your network providers, that's going to decrease your liability associated with your business as well and give you a bigger paycheck if and when you sell. That was a long-winded answer. I don't know if I touched on everything you need me to.
Really good stuff. We actually have some questions here. So we're gonna go back real quick to the DMCA stuff, even though we try to get off that. It's not a problem. In the DMCA statute, what one particular person says, most of the people that's listening, they are going to be WISPs or ISPs, and they're not hosting providers. Therefore, they do not have any content to take down. And I'm just going to read this verbatim. As mentioned in the DMCA statute, most WISPs are pass-through carriers, and as a pass-through carrier are exempt. DMCA takedown notices are only for content providers. So does that mean we're exempt or not? Or is that something you need to contact your own lawyer and get a definitive answer?
Well, I don't disagree with what was said there, by the way. The problem is there's a lot of nuance and issues here. And let's not forget what we're talking about. And we're talking about trying to avoid a lawsuit or being a named party to a copyright infringement lawsuit, which immediately you think about having to shell out at least $5,000 for an attorney retainer to help defend you, even to get your name off the damn lawsuit. So the problem is the Copyright Act has a contributory copyright infringement clauses, and anybody that profits from the release of pirated or copyrighted information that is not, and let's remember that it could be legitimate information, by the way, legitimate material that isn't pirated. There's just some sort of contract dispute between distributor A and distributor B, and you can get sucked into that lawsuit. So the DMCA, if you can hang on to it somehow and use that as a defense, it only helps. Now, I think what that question said is technically correct, that if you're a pass-through, the DMCA really doesn't apply. But I think if we can include it or incorporate it in our business process and try to make it apply, it can only help us.
Very good.
Right, because the copyright people are going to cast a large net when they're suing.
They do. I've been a part of it, and they will attach everybody they possibly can, and it's not easy. What happens is you get some large law firm in Washington, D.C. that now they're getting a little better trained. They won't always go after the ISPs. But usually they'll include them just because. And now everybody's got to hire a damn lawyer and try and get off the lawsuit and find some representation in Washington. It's a costly adventure that if you can put your nails into the DMC to help, it's not a bad thing.
There we go. So some other questions we got here since we got you, and I know your time is limited here. In your opinion, the net neutrality stuff comes up, and they define reasonable network management. And the question is, in your opinion, reasonable network management, is that sufficient to allow an ISP to ban or block BitTorrent traffic, since there's no way to stop it from degrading the network if there's a flood of incoming requests that swamps the ISP? Before you get on that, I want to make sure I point this out. The latest Title II stuff actually does define reasonable network management much better than the original net neutrality statement. And I'd have to Google it, but I believe it specifically says reasonable network management, there must be a technical reason to do so, not a business decision. If it's a business reason, then that's not a reasonable network management. So I want to make sure I point that out. I will tell everybody right now is that I know plenty of WISPs that allow BitTorrent. The problem I would feel in this is that if you just use BitTorrent is a legal application. The content that's transferred over it in most cases is illegal. And you trying to block that is, first off, can you block it? The answer is very seldom will you actually catch everything. There is always ways around it. Okay?
Whack-a-mole.
Yeah, I mean, there's tons of ways. And to be perfectly honest with you, go download the latest version of uTorrent. There is a wonderful box that says, force all connections to be encrypted. Good luck trying to block encrypted connections. Okay? It is what it is. So while you can sit there and say that doesn't necessarily mean that that's going to stop it. And I would definitely fear, just from the general point of view of if it's a lawful content, then it should be allowed. I would think that that's a bad thing. What you probably can do better is to prevent a large-scale number of connections, both from your client and from to your client. And that usually that prevents the flood of requests, number one. It prevents the large packet counts and such. And it doesn't matter if it's BitTorrent or some other type of peer-to-peer application in many cases. With that, Larry, your comments.
This is all so new right now. I'm really loath to give an opinion. It's clear to me that there's some significant cost shifting going on, and unfortunately it's on the backs of, the WISPs for sure and the other local ISPs. The problem is if there can, there's a couple of issues, I think. One of them is, are you discriminating in some way relating to content? And if you are, I think you're possibly opening yourself up to a cause of action in civil court or a complaint. Now, we haven't seen too many complaints yet because this is so new. But I caution a broad-brushed policy over some type of system or program, whether you believe it has legitimate traffic or not. I think at least until this gets sorted out a little further and vetted, at least by the bigger players, let them spend the money on trying to get the better definitions into place. That would be and I know I'm giving you a very conservative opinion here, but
well, that's totally fair because, like you said, this is something new on the horizon, and I think what Dennis mentioned in referring to the question is, reasonable network management. If he's crushing the pipe and he's ruining the connection for everyone else, he could shut off on my network, and I call him up and explain to him, you can't be doing this, man. Well, you're ruining the connection for everyone else. How would you like it if I told all the people on that network where you live and what you're doing, and they'll come burn your house down? Of course, I would never say that, but love to say it.
Well, the other side of this, and the particular person who is on the chat actually said this, is that Google Fiber does have a clause in its acceptable use policy forbidding servers on residential connections.
Me too.
Okay, I have that on mine, and that is a technical reason. The reason for that is you will use, let me rephrase this, you do not use bandwidth. Your customers or whoever is going to whatever server that is connected to your network is the one that's consuming the bandwidth. And because of that, the bandwidth usage over a connection that's only to be used by that home is being consumed whenever no one is there. So I definitely think that is an acceptable policy. We actually, I can tell you right now, many of my customers block many inbound ports in the effort to prevent two things. One, denial of service attacks such as DDoS, DNS amplification, NTP amplification attacks, number one. And number two, they don't want unless you pay for a business connection, that you understand that there will be connections and you understand how to properly firewall and protect your services. We take it upon ourselves to firewall our residential customers because most people will not understand how to do that. Heck, back in the 90s, 99, 2000, somewhere in there, whenever I had my first home, I had a DSL from AT&T, and back then, outbound port 25 was blocked. You had to call them and get it to be unblocked. So with that said, I guess one of the last questions, since we're a little bit over, is that legitimate? Is that something that you can do without anybody, complaining? And I also note that as long as you tell people this, and this is part of your terms and services, in that they know that prior to them signing up for the service, I don't see how that could be misconstrued as, hey, we didn't tell you.
I agree with that. I do. The other, and I got to be honest with you. I'm not an expert at telecommunications by a far stretch. But what I can tell you is that you have a legitimate reason. The fact that you have a certain amount of capacity. Period. The net neutrality laws that what's coming out, I'm not saying requires you to provide infinite resources to everybody, number one. And so you are allowed to partition or take reasonable measures to ensure that one person's use doesn't jeopardize everybody else's. And so I think, if you're putting reasonable rules in place relating to how your network is structured or what the overall ability of your network is, I think you got a legitimate argument if somebody does want to file a complaint or file a lawsuit. The other piece to this, I think, is at least everything I'm reading applies to consumers and what they can get from the edge providers, right? The YouTubes and the Netflix of the world. That's not the end user as a publisher. It's the end user as a consumer. So I think you would even have a stronger argument to limit the at least what is going the other way on your networks, and I think you can make a reasonable argument for that. Finally, just when we're dealing with legal issues, remember, you're always going to get a complaint first. And I would suggest when you start getting that complaint, then find a reasonable attorney that has some expertise in this area to advise you on whether you need to change your policy or not. So the point is until you receive that first complaint and the fact that things are still very much uncertain, you have some room to maneuver and try and manage your network for the benefit of all your users.
There we go.
We're kind of over our time, Larry. Unless you got something else that you want to share with us, I really appreciate you being on the show, folks. You've gotten some really good advice from an attorney that knows technology, and we've got the copyright thing with the DMCA to sign up for to give us some safe harbor. I believe that's what I'm understanding. So we've gotten a lot of good advice from Larry. Larry, can you share with us if any of the ISPs out there are interested in contacting you? How would they go about talking with you further about the business-related topics?
Sure. If I haven't turned them off from my blathering, Our website's at www.l4sb.com. That's L for law, 4, S for small, and B for business.com. And all our contact information is there. And, feel free to call or ask questions. And if we can help you, we'll be happy to. A lot of times there'll be specialized areas or needs, and we're happy to, refer other lawyers or point people in the right directions if they need that. And thanks for having me on. It was a pleasure.
You bet. And I've learned a lot. And like you mentioned earlier, you're a small business yourself, and you're trying to help out and not play the big lawyer game of $5,000 retainage fees and never getting a phone call back. That's not what Larry does here, guys.
Thanks, Steve.
Well, Dennis, you got anything else?
I think we're good. Just remember, ladies and gentlemen, that we do have WISPapalooza coming up. It is important. Go ahead and sign up, get signed up, and make sure you go to that show. If you have any questions about or for our guest speaker, remember that is www.l4sb.com. You can visit him online, ask him questions as needed. Apologize to the person who tried to call in. I apologize we did not grab your call. But continuing on, we hope to see everybody back next week. What do we have on the... Do we have something?
We have a guy named Jay Rohr with Mail Extreme. They're a vendor that I used to mail out my invoices that I send out for people that want snail mail. So he was going to be on the show to talk about what MailX can do for ISPs to help them with their processes of not having to fold up the invoice, put it in an envelope, and put a stamp on it. It's actually a really good value, and so he'll be on the show next week, Dennis.
There we go. With that said, I am all out of what's going on.
Thanks, everyone.
You want to close this up, Steve?
Yeah, let's close it up. Thanks a lot, guys. We'll see you next week.
Take care.
Thank you for listening to ISP Radio. We hope you've gained new insights and additional wisdom in our industry as well as your business. Please remember to visit our show sponsors via the links on ispradio.com. If you're interested in becoming a show sponsor, contact us at sales@ispradio.com. Now go out there and push those packets as fast as you can. Good luck and Godspeed.